Hello and welcome to this two-part CPD cast series on competition law compliance, in which I'm joined by Sophie Lawrance from Bristows. Sophie specialises in competition law, and she has a particular interest in working with businesses in technology and pharmaceutical sectors and in relation to the competition issues that arise in connection with standardised technology. In this part 1, Sophie will explain what is meant by competition law compliance. She'll look at what competition law is all about, the kinds of behaviour that can infringe competition law, and what companies should be doing and not doing in order to ensure compliance. In part 2, Sophie will look at the way in which regulators can regulate the future conduct of companies, the penalty of director disqualification, which is specific to the United Kingdom. She'll look at the remit of private enforcement, the reasons for companies to implement competition compliance programmes, the ways in which such programmes should be monitored, and the steps directors should take if he or she thinks that an infringement has taken place. So Sophie, this podcast is on competition law compliance. What do we mean when we say compliance?
Essentially, the aim of competition law compliance is to ensure that EU and UK competition laws are not breached. Now, you might think that that's a relatively simple matter to avoid breaching the law, but there are a couple of reasons why it's not always so straightforward in the competition law context, and why it's therefore necessary to have some form of competition law compliance programme in place. So first, it's not always easy to determine whether a competition law infringement has taken place or not. In some cases, certain behaviours will be justifiable in some economic contexts, but will infringe the competition rules in others. So one way to sort of look at it is that there is a spectrum of anti-competitive behaviour ranging from deliberate anti-competitive conduct, such as a price-fixing cartel or a deliberate attempt to foreclose a new market entrant, to other sorts of conduct or agreements which would normally promote competition but might, depending on the circumstances, stray into anti-competitive conduct. And the existence of these grey areas means that it's not always possible to be certain in advance how a regulator is going to assess certain types of behaviour. So compliance is going to come down, as we're going to discuss in a bit more detail later, to assessing levels of risk and ensuring that the possible implications of a course of action are fully considered before it's undertaken. So that was the first reason why having a compliance programme for competition law is necessary or useful. Secondly, compliance issues can also arise around a company in a number of different business contexts. Now, contrast the situation, for example, with a contract where there will be a number of specific employees who are responsible for operating the day-to-day running of a contract. They will know the terms of the contract and know how to avoid breaching it. Competition law, however, can arise pretty much anywhere in the business, at least where it's outward-facing. So it could be breached by employees with a number of different functions. So, for example, those dealing with customers or clients, those dealing with upstream suppliers, and those who have dealings with competitors. That sort of interaction can often come in circumstances where there isn't any direct oversight from in-house or external counsel. So those are a couple of reasons why a compliance programme is necessary for competition law. The important thing to note is also that the consequence of breaching competition law can be extremely serious. So that obviously raises the stakes as to why a competition compliance programme is important. So just to sum up my first answer, when competition lawyers talk about compliance, what they're really talking about is how to reduce the risks of breaching competition law and how effective compliance can be achieved.
Can you give us an idea of the big picture? So what is competition law all about?
Broadly speaking, the purpose of competition law in the EU is to promote and maintain competition on the market by regulating the anti-competitive conduct by companies. And there are a number of ancillary aims within that. There's the promotion of free trade around the EU, so between different EU member states. There is the prohibiting of abusive behaviour by a company which is dominant on the market. And there is also supervision of certain mergers and acquisitions. Now, listeners are likely to be aware that there can sometimes be a tension between the big picture in terms of how competition in the market is actually affected and the approach which is taken by the regulators, which can sometimes seem more abstract and perhaps less forgiving. An example of this sort of tension is the approach to information sharing. Up-to-date commercial information can be a company's lifeblood to allow it to compete effectively on the market, to position itself vis-à-vis its competitors. But the EU competition authorities have and do come down quite hard on information sharing between competitors. And indeed, I was heard recently that a member of the European Commission described information sharing agreements and practices as akin to a cartel. So there can be a sort of gap between the theory and the practice in this area. So one of the things we're going to talk about throughout this podcast is companies need to consider internally and take a view on what their attitude to risk is.
What are the kinds of behaviour that can infringe competition law, and what should companies be trying to avoid by being compliant then?
So just going into a little bit more detail, we just mentioned some of the sorts of conduct before, but the main area on which a compliance programme will typically focus is avoiding cartel-type conduct. So when I say cartel-type conduct, what I mean is agreements between competitors to fix prices, to share or allocate markets, to restrict output, or to carry out bid rigging, so where there's a procurement process and the tenderers agree between themselves who's going to win, or enter into sort of bid rotation agreements or something of that kind. And those types of conducts are the classic examples of really pretty unambiguously anti-competitive behaviour, where competitors collude together to deliberately increase their profits at the expense of consumers or other competitors. And in the European context, agreements of this kind are prohibited by Article 101 of the Treaty on the Functioning of the European Union and national equivalents. So in the UK, the national equivalent is the Chapter 1 prohibition from the Competition Act 1998. Secondly, the main body of rules relate to abuse of a dominant position, and that is regulated by Article 102 of the Treaty on the Functioning of the European Union. This set of rules applies to companies with significant market power, those which could be described as dominant. And those companies are subject to what's described as a special responsibility not to impair the process of competition. And examples of conduct which have been held to breach this rule would include refusals to license or supply, tying, excessive or predatory pricing, product bundling, and a number of other sorts of conduct, because in fact the categories of types of behaviour which could infringe this prohibition aren't closed. So there are always new sorts of conduct which could come under this heading. It's worth noting that certain sectors give rise to a greater number of issues in this area. A sector under particular scrutiny at the moment is the pharmaceutical sector, which, due to the nature of the products with new drugs, often gives rise to particularly narrow markets, which can lead to a finding of dominance relatively easily. Other sectors which can give rise to similar issues are those which have been, for example, recently liberalised, or where there are at least former sort of incumbents who have a very strong market position. Compliance programmes aren't really designed to look for potential merger situations, but companies should keep an eye on whether any planned acquisition or merger in their field could lead it to holding a dominant position, or could in some ways increase its risks of anti-competitive behaviour on the market. And they should also, of course, be aware that a merger situation may need to be notified to the relevant authorities. I mentioned before that the EU competition law also places great importance on the free movement of goods around the EU, so effectively free trade between all the different member states. And this is something which is quite specific to Europe. For example, the US antitrust rules don't have anything similar to this because they don't face the same risk of market segmentation. Competition law isn't all about cartels and abuses of a dominant position, though. Certain more day-to-day agreements can also contain potential anti-competitive provisions. So, for example, distribution or licensing, even though they may not be entered into between competitors, they can breach competition law. And an example of a sort of activity that's in that context, which is of particular interest to regulators, would be resale price maintenance, or something which contravenes the free movement of goods principles, so market partitioning down territorial lines. So when companies are looking at drawing up a practical competition compliance policy, they need to think about how competition law issues can arise based on the everyday activity of the company. So, grouping the sorts of conduct which can arise by reference to whether activities are being carried out with suppliers or distributors, so those are people who are not generally competitors, or those which are with competitors where the greater risks arise.
Where should companies start when they are devising a coherent compliance programme then?
We spoke a little bit earlier about companies' attitude to risk, and that is going to be a key driver in establishing an appropriate compliance programme. Whilst it must obviously be the goal of any company to avoid egregious cartel-type conduct, many other areas of competition law, as I've explained, are open to interpretation and argument. So a company which believes that it is willing to make arguments to a regulator or in a civil litigation context will probably have a more nuanced approach to its compliance programmes than a company which really just wants to keep competition law at arm's length. Other relevant factors which are going to determine what an individual compliance programme will look like depend on the company's position on the markets on which it's active, the history of the company, and the general competitive environment. And it's the combination of these factors which is going to drive the company's policy on compliance. So, for example, a company with large market shares will need to place much greater emphasis on potential abuses of a dominant position, whereas a small company operating in a competitive market may be able to place a bit less emphasis on the risks associated with market power. But it's important to note that even companies with very small market shares can be found guilty of cartel activity, and indeed have been. So this aspect of competition law compliance needs to be emphasised in all cases. So those were a number of factors which can vary what a competition law compliance programme is going to look like, but there are a number of common threads which are going to apply to pretty much any competition law compliance programme. A culture of compliance in a company needs to be pervasive, and it needs to be driven by senior management, so it needs to come from above. Senior directors and CEOs need to take ownership of their corporate competition compliance. This means more than paying just lip service. Senior staff need to obviously attend the training sessions and engage with the issues. They need to bear it in mind in their day-to-day business and just keep a weather eye on what the staff for whom they're responsible, how they are carrying out their work. And it's strongly in their interest to do that, because if you consider the fact that in a number of jurisdictions, including the UK, breach of competition law is potentially criminal, particularly where you're looking at cartel-type conduct. And even if there are no criminal proceedings, companies can be fined millions and millions of pounds or dollars or euros, and they may also face very significant third-party claims, potentially by a number of different companies. And reputational damage tends to flow from breaches of competition law as well. So rather than thinking about competition law compliance as a simple tick-box exercise, it's often going to be more successful for a company to aim for a spirit of fair competition throughout their organisation, to sort of embody an ethos of competition compliance. And a practical example of this might be, for example, for managers to think about how staff are incentivised. If their staff are purely driven by profit maximisation as their only goal, then that can sometimes lead to an environment where anti-competitive conduct could flourish. And that's not to say that every single sort of bonus-driven scheme is going to give rise to problems, but it's just something that needs to be borne in mind when these schemes are being structured. It's also worthwhile staying up to date with legal developments in the competition law area. If other companies in your sector are being investigated, then there's going to be higher risks of an investigation moving to other companies in the industry. Also, sector inquiries and market investigations can be a sort of interesting weather vane for the way the policies of the competition authorities are developing. Look, for example, at the pharmaceutical sector inquiry that was carried out into the pharmaceutical industry a few years ago by the European Commission. That's been rapidly followed by a succession of individual company investigations investigating alleged infringements. And there can also be interesting sort of policy implications from market investigations. There's been an investigation into the big four audit companies in the UK carried out by the Competition Commission over the last couple of years. And there's been a lot of lobbying, both by the companies that are under investigation themselves and by their customers and also by their competitors. So there's been a lot of sort of political lobbying, jostling for position as to how policy in this area is going to develop. And a company which stays away from that is not likely to get what it would like to see happening in the marketplace. So I think it's fair to say that the priorities of regulators can also be important in keeping an eye on competition law compliance. So, for example, at the moment, the UK competition law regime is undergoing reform. They're looking at new criminal sanctions, and there's a new competition and markets authority being created, and as well as changes to the merger regime. And competition regulators also publish annual plans, which can be an interesting way of ascertaining what they are likely to be looking at in the coming year.
Well, thanks, Sophie. I think you're going to give us some more detailed practical tips at the end of the podcast. So for now, so we understand the stakes, what are the risks of not complying with competition law?
Well, I've mentioned some of them already, but just to go through it in a bit more detail, the consequences of failing to comply with competition law can be divided into two main categories, public and private. So public enforcement can be triggered by complaints made to authorities about the conduct of particular companies, or they can be the result of an application for leniency. So that's where a company comes to a regulator and says, look, it looks as though we've infringed the competition rules, and here's all the evidence showing how we did it and which other companies were involved. In some cases, authorities do start sector inquiries or investigations based on their own concerns about the operation of a market or a particular practice. If an investigation leads to a finding of anti-competitive conduct, then, as I mentioned, the authority can impose fines, which can be extremely high. Take a look at for example, at the participants in the recent computer and TV monitor tubes cartel. They were collectively fined nearly 1.5 billion euros in 2012, including 705 million just for Philips. Not only that, but the finding of competition law infringement in the worst cases can lead to criminal proceedings, including potential prison sentences or disqualification of directors. In less serious cases, companies may be able to settle the competition investigation by giving commitments about their future conduct, but that obviously has a significant impact on what they can and can't do on the market afterwards. So that was all the public enforcement. Private enforcement, on the other hand, is the enforcement of competition rules by one company or customer against another company. That can happen in conjunction with public enforcement. So where an infringement finding has been reached, then companies can make a follow-on damages claim. They can also arise independently, so a separate standalone action can be brought for breach of the competition rules. Another practical consequence is the enforceability of agreements. If an agreement has an anti-competitive term, then that agreement will be unenforceable. And we're not only talking about damages and unenforceability, there can also be claims for injunctions and any of the other sort of normal civil law remedies. Whether we're talking about public or private enforcement, these sorts of breaches can have very serious practical and commercial consequences for the companies involved.
Let's start then by talking about public enforcement. Who are the regulators in charge of enforcing competition law?
In Europe, the main regulator is the European Commission, specifically the Directorate General for Competition, based in Brussels. The European Commission applies Articles 101 and 102 of the Treaty on the Functioning of the European Union in cases where it believes that the conduct in question is capable of affecting trade between member states, and that's effectively just a jurisdictional test to check that it is EU competition law which is appropriate to be applied rather than national competition law. However, about 10 years ago, Regulation 1 of 2003 decentralised enforcement so that national authorities can now also apply Articles 101 and 102 rather than solely their national provisions in cases if there is an effect on interstate trade. And the reasons they would do that would be where conduct is based primarily in one country or maybe two countries, but doesn't have such wide effects across the European Union. Another regulator to be aware of is the EFTA Surveillance Authority. So that is also based in Brussels, but it regulates competition rules for Norway, Iceland and Liechtenstein. So they're countries which are based outside the EU but have a very close relationship with it. And in effect, the same set of competition rules apply in those EFTA countries. The national competition regulators also have a very important role to play. So these are, for example, the Bundeskartellamt in Germany, the Autorité de la Concurrence in France, and at the moment the Office of Fair Trading in the UK, and also the Competition Commission in the UK. And those two bodies have different remits and are going to be reformed into the single Competition and Markets Authority next year. There are also a number of specific sectoral regulators, such as in the UK we have Ofcom, which is allowed to apply competition law in the telecommunications sector. As I've mentioned, we also have the criminal law sanctions in some member states such as the UK, and where the criminal law is being applied, the serious fraud office is likely to be involved in addition to the OFT, because they simply have the experience of bringing criminal type proceedings. And we're talking here primarily about the EU context, but it's Important to note that competition and antitrust laws are in force in most countries in the world, and where you're looking at companies which have international business, they may often be at risk of facing investigations in a number of different jurisdictions. The US obviously has a very long established regime enforced by the Federal Trade Commission and the Department of Justice. China has a much newer set of antitrust laws, but it's becoming much more active in this area, and the body in China that regulates this is known as MOFCOM. So it's important that competition compliance, for a global company, competition law compliance needs to be considered on a global basis.
So, Sophie, how does the relevant regulator go about enforcing competition law?
The main tool that regulators have at their disposal is investigations, and investigations lead then to infringement findings and fines and so on. So authorities can launch an investigation in a number of different contexts. The classic context is that they launch an investigation based on a complaint. Increasingly, however, they will also launch investigations when a leniency application has been made. And as I mentioned just a minute ago, a leniency application is effectively a company coming forward, holding its hands up and saying, we've infringed the competition rules, please forgive us, effectively. And so by cooperating with the authorities, by providing with a lot of evidence which may help to incriminate other companies, they are let off fines, either in whole or in part. Competition authorities do, however, also have the power just to start investigations on their own initiative if they become aware that there may be a problem in a particular sector or company. So once an investigation is started, the competition authorities have a number of very significant powers which can make the investigation a very significant burden for companies. So they can make requests for information, and they will be written, and they are often very onerous, require provision of a great deal of detailed information and supporting documents, often have to be answered in a very short time frame, and can then effectively become binding on the company afterwards, because it may be difficult then to argue something different at a later stage. So there's something to take very seriously. I've already mentioned that documents can be requested. The company can also obtain documents by searching at the premises of the company. So this is often referred to as the carrying out of a dawn raid. In the competition law context, unlike the criminal context, this doesn't really normally happen at dawn. It will normally happen within business hours. But the competition authority will turn up at the company with no forewarning and simply say, we require to be entered, and we're going to search your business for documents and evidence in relation to what we believe has been a piece of anti-competitive conduct which has been carried out. The authorities in that context also have the power to ask employees for on-the-spot explanations, to carry out interviews, and in some cases they can even search outside the business premises. So other business property, such as cars, can be searched, and they may, if there's evidence that business has been carried on from private premises, such as a director's home, then they can even, with police support, turn up at your home to search. And just to give a recent example, which is really quite a random one, but a recent example of a dawn raid that's been in the news was one that involved three of the world's largest oil companies, BP, Shell and Statoil of Norway. And it's important to sort of be aware that these unannounced inspections are increasingly coordinated globally. As I've mentioned, competition breaches can often have international ramifications. And so it may well be that a raid will be coordinated between the EU competition authorities and the US antitrust authorities, potentially starting after lunch in Europe, so that it starts at exactly the same time in the EU and US. So larger companies in particular should make sure that their training covers how to deal with dawn raid situations. And that sort of training it's a little bit different from the more general compliance training, because it's going to need to cover even staff like receptionists, who are the ones who will be the ones to effectively welcome the competition authorities into the building. Receptionists need to know how to deal with that situation. So the fact that they will have to issue badges to these people, provided appropriate identification is provided, and that they should also get in immediate contact with in-house counsel or senior director so that they know what's going on. So as part of any compliance programme, it's worth including some sort of training designed to highlight the issues that can come up in this dawn raid context. And one very useful practical way of doing that is to carry out role plays to explain the sorts of issues which can arise. And any training in this area also needs to highlight the fact that different bodies, so whether you're talking about the European Commission or the RFT or Ofcom, each body has slightly different powers. So some of them, for example, can demand interviews be carried out, whereas others can't. Some of them can take original copies, some of them can only take copies of documents. So that's effectively the beginning of the investigation, really. Once an investigation has been opened, it can last for a number of years while the authorities collect information and consider whether to issue a statement of objections, which is the formal statement to the company about the infringement that is believed to have been committed and which the company then has a right to respond to. Sometimes that will happen relatively quickly, as can be as little as a year from the start of an investigation to a statement of objections, but it can often be much longer, 3 or 4 years or even longer. And this is obviously a very significant burden on companies in terms of the management time dealing with it, the cost of dealing with it, and the reputation damage. And I think it's probably fair to say that companies which have been involved in an investigation of this kind would say that the only really successful way of dealing with the competition authorities is just to ensure that an investigation of this kind doesn't happen in the first place. Because once an investigation of this kind has been opened, it can be difficult to extricate itself.
If a regulator does get to the stage of finding an infringement, what penalties do companies face?
I've already mentioned the potential for high fines. So if there's a finding of infringement, then the European Commission has the power to impose a fine of up to 10% of the group worldwide turnover of the undertaking. I mean, that's a high watermark. Generally, there'll be quite significant reductions on that, but nevertheless, as we've seen, the fines can be significant. The RFT, in fact, has a upper threshold of 30% of the undertaking's UK turnover. The Commission will usually seek to impose the fine on the highest organisational level possible, so in order to capture the greatest amount of turnover. To do that, it needs to show that a parent company exerted decisive influence over its subsidiary.
OK, well, Sophie, if we can stop there and continue to look at penalties that can be enforced by regulators on companies for competition law infringement in Part 2 of this CPD Cast series. That concludes Part 1 of this 2-part CPD Cast series.